Cool. Welcome everyone. Thank you for tuning in to this session, this Q&A session, hosted by Trowbridge Law Group. My name is Jon Nieh. I'm one of the founding partners here at Trowbridge Nieh. And that's my partner Gene on the screen along with me. If you are joining us for the first time today, a quick little introduction about our law firm. We are securities and crowdfunding attorneys. If you're a real estate syndicator, you've probably at some point seen my partner Gene talk. He's been in this game for a while now, pretty well known in syndication space. Myself, I've been doing this for about 8 years now. I graduated law school in 2016. I think I met Gene pretty shortly thereafter. Have been pretty much working with him as an attorney since then. And in 2020 is when Gene and I decided to form this new law firm and become partners. So that being said, this is a Q&A session, so feel free to ask any question you want. I think there is a chat box where you could type your questions there. You can ask me anything you want about securities, about syndications, crowdfunding, Reg D, Reg A, Reg CF. Any question that you have, feel free to type it in the box, and I will try my best to answer it. That being said, I will start with like a brief introduction to syndications and securities, like the rules that you have to know to raise money legally. And then the topic for today's session that we wanted to talk about was capital calls. So it's pretty relevant in today's market. A lot of our clients, a lot of sponsors, a lot of syndicators are having issues with their property, with either loans or rent growth or whatever the case may be. But a lot of people have been dealing with this issue of having to do a capital call. So I wanted to talk briefly about, some of the issues that you'll have to face if you're a syndicator, and also if you're a passive investor in a deal. If the sponsor is going through this process right now, what you kind of have to know and look out for. So that being said, first thing I wanted to talk about, though, is a little bit of a disclaimer. I'm an attorney, and although I'm an attorney for my clients, for this purpose, for this Q&A webinar, I'm not your guys' attorney. So please do not take any of this as legal advice. If you want legal advice, we need to establish some sort of attorney-client relationship, and that means you have to hire our law firm to represent you. So if you do want legal advice, please go through that process. So, brief overview of syndications and securities rules. So this picture is basically a typical syndication. This is what a typical syndication looks like. In our practice, we see a lot of LLCs. It's kind of the go-to entity for syndicating a deal. I know there's other types of entities out there. And there's other, terms that are kind of used interchangeably in our space, like LPGP. But for the purposes of this webinar, let's just assume everything is an LLC, right? So typical syndication, you have an LLC that is owning the property, and that's what we call the investment LLC. Your passive investors buy interest in that investment LLC and become members of that LLC. And then the sponsor or the syndicator, they manage the deal through the investment LLC, through this relationship that they create with the manager LLC. So the manager LLC is controlled by the syndicator. It manages the investment LLC on behalf of the members or the investors, and the investment LLC owns the underlying property. That's basically what a syndication is. But really the question you need to be thinking about is, does this transaction involve the sale of a security? What is a security? Well, to answer that, we have something called the Howey test. It's the de facto way of determining whether or not you are selling a security. I won't go into the details of how the Howey test came about, but basically it's a 4-prong test. All 4 prongs have to be met, and if all 4 prongs are met, then that means you are selling a security. But the prongs are: it involves investment of money, there's a common enterprise, investors have an expectation of profits, and those profits are solely realized from the efforts of a promoter, which basically means there's this passive nature involved in the deal where the investors aren't doing the work, it's the promoter that's doing the work. Well, if you look at that picture again of a syndication, and if this is how your deal is set up, with a manager LLC managing the investment LLC on behalf of the investors/members, then you are selling securities, because there is an investment of money. Investors are putting capital into the investment LLC. The common enterprise is the fact that all of the investor money, all of the investors' funds are being pooled together in this investment LLC for this purpose of purchasing a property. Investors are going into it expecting to make a profit, right? This isn't GoFundMe. Investors expect to make a return on their investment. So that 3rd prong of the Howey test is met. And then lastly, the manager or the syndicator is the one in charge. They're the ones running the deal. They're the ones that are making all the decisions on behalf of the investors. And if that's the case, then the 4th prong, solely from the efforts of the promoter, that's also met. So all 4 prongs are met, you are selling securities. If that is the case, then you are in the realm of the SEC, the Securities Exchange Commission, and they have 2 basic rules that you have to follow anytime you are selling securities. Number 1, you are required to disclose all material information to your investors. And material information is basically, put yourselves in the shoes of a reasonable investor. What information would you want to know to make a decision on whether or not to invest? I mean, it could be very, very, very detailed information, or it could be very basic information, depending on the company that is raising the money that's selling securities, or the types of investors that are being brought into the deal. But the point I'm trying to make is it depends on a deal by deal basis. It depends on a case or company by company basis. But that's the first rule that you have to follow is you are always required to provide full disclosure to your investors. And the second rule you have to follow is you are supposed to register your securities with the SEC unless you apply for some sort of exemption. So registration is essentially becoming a public company. So when a company has an IPO, they're essentially registering their securities with the SEC for the first time. And you can imagine how expensive and how much time it takes to become a public company. That's not really an option for syndicators. That's not really an option for a lot of companies that are looking to sell securities. Well, what do you got to do? You have to find an exemption. So what exemptions are available? Basically, there are 4 main exemptions that companies use. They're kind of listed down there at the bottom, which are Rule 506B, Rule 506C, Regulation A+, and Regulation CF, or Regulation Crowdfunding. And the numbers on the screen to give you an idea of how much capital is raised under each exemption each year. So these numbers are pulled from a report from 2023. So it's a one-year period of analysis. But basically, from the middle of 2022 to 2023, how much money was raised under each type of exemption? So Regulation D, which includes both 506B and 506C, a total of $2.9 trillion, trillion with a T, was raised utilizing Regulation D. Specifically, though, for 506B, $2.7 trillion was raised in that year. 506C, a total of $169 billion was raised. Regulation A+, $1.5 billion, and then at the bottom, Regulation CF, $352 billion. The numbers to the right, that is the median the average basically for each offering under those exemptions. So, 506B had a median offering size of 1.2 million. 506C had a median offering size of 750,000. Regulation A plus had a median offering size of 1.6 million. And Regulation CF had a median size of 100,000. And to kind of illustrate these, sizes or discrepancies between the types of offerings, here's a little pie chart. You can see blue is 506B, orange is 506C, and then Reg A and Reg CF, you actually can't even see, like physically can't see because the slice is that small, like so tiny compared to the other two. And why is that the case, right? Why is 506B predominantly the exemption that almost everyone uses? Well, in my opinion, it's, two reasons: time and money. From what I've seen and based on, the requirements that you have to go through to do a Reg CF, Reg A, or 506C offering, those types of offerings take a little bit longer and can definitely cost more money. So to give you an example, Regulation A, you're probably going to have to spend upwards of 50,000, maybe even over $100,000 in legal and accounting costs to do a Regulation A offering. And on top of that, there's an approval process you have to go through before you could start raising money under Regulation A. So, if you're syndicating a deal and you have a property that's currently under contract and you need to close within, 30 or 60 days, that's just not feasible under Regulation A. Similarly, under Regulation CF, legal costs, can be a little bit more because there's, some ongoing reporting that you have to do when you do a regulation crowdfunding. And on top of that, just like Reg A, there's kind of an approval process that you have to go through to do a Reg CF. So, if you have a property under contract, then those two types of offerings generally aren't available to you. 506C, though, it's, I would say it's about equivalent to 506B for cost, right? The cost to do a 506C and a 506B are about equivalent. The speed at which you can do a 506B versus a 506C is about equivalent as well. Both of those are under Regulation D, which does not have an approval process with the SEC. So the only thing that you need to do a 506B or 506C offering, as far as the SEC is concerned, is file what's known as the Form D. And you can do that basically as soon as you want, right? If the company is set up and you have an EIN and you have a bank account open, all you do is file the Form D with the SEC and you can start raising money the same day. So it's very, very quick to do those types of offerings. And again, the costs are, much, much less as compared to Regulation A and Reg CF. So if you are syndicating a deal and you're syndicating the deal for the first time, our recommendation, like you don't have a track record of syndicating or raising money, our recommendation would generally be to do a 506B offering as your first raise, because that type of offering doesn't involve general solicitation. So the people that you are raising money from are the people that you have a pre-existing relationship with. And that's why a lot of people, when you see someone saying, hey, I'm going to do a friends and family offering, that's what they're really talking about, is a 506B offering, because they're raising money from their friends and family. And if you don't have a track record, that's generally who you're going to have to start raising money from initially, because one of the questions investors who don't know you, the question that they're going to ask you is, have you done this before? And that's a huge hurdle to get over. But if you don't have a track record, obviously your friends and family, the people that know you the best, they're investing in kind of their relationship with you. They're not really investing. They don't care about your track record, right? Because you don't have a track record. They're your friends and family, and that's why they're investing in your deal. Once you develop that track record, that's when I would say you can, think about maybe utilizing one of the other exemptions like 506C, Reg A, or Reg CF that allow for general advertising, that allow you to go out and solicit investors that you don't know. And generally speaking, most of our clients who want to do that will utilize 506C. And that kind of, flows with this chart, which shows that, most people are using 506B. But if you do need to advertise, then 506C is probably your best bet, again, because of time and money. The only drawback with the 506C offering is every investor that comes into your deal has to be accredited, and you have to go through steps to verify that they're accredited, which, granted, maybe like 5-6 years ago, that was more of an issue. But today, I think, number one, there's like millions of accredited investors in this country. So, finding accredited investors for your deal is not that difficult. And then number two, because 506C has been around for almost 10 years now, a lot of accredited investors have gone through this verification process already. They're used to it, or maybe they already have a verification letter that they could just give to you. So it's a lot easier to get over that verification hurdle. But that being said, if you have specific questions about what type of offering you should do for your deal, I'm more than happy to answer that right now in this session, or if you wanted to, schedule a private consultation with me afterward, I'm more than happy to do that with you. But so that's the kind of general overview of the exemptions that are available and kind of the process that you have to go through if you're a syndicator looking to raise money for your deal. The next thing I wanted to talk about were capital calls. So this is a pretty big issue, recently within the last, 6 months to a year or so. A lot of, number one, interest rates were raised over a year ago, and that's been causing a lot of issues for our clients and investors in the real estate market. A lot of people who acquire properties that utilize some sort of bridge debt or loans that were dependent on interest rates, they're running into issues now because they're I guess they just need more money to operate their deals because of issues that that I just mentioned. Anyways, that being said, a lot of our clients are going through this process now of having to go through capital calls. We get questions all the time about, what do I need to do if I need to do a capital call? Do I need to amend my documents to kind of make it easier? But the first thing that I wanted to talk about is, number one, the thing that you have to realize is the operating agreement is the document that controls everything, not just capital calls. It controls how the LLC is run, voting rights, disputes between members and the manager, everything that governs the LLC and how the LLC is run is within the operating agreement. And the capital call provision is one of those provisions. So if you have specific questions about your company that you're running right now as a sponsor, or if you're an investor in that company and you have questions about the capital call provision, well, your LLC's operating agreement is going to govern those questions, right? So I can't really speak to, unless I was the one that drafted those operating agreements, I can't speak to what those are companies, the process they have to go through for their capital calls. So that being said, I'll kind of give you like my thoughts on capital calls and kind of examples that I've seen and that we kind of put in our documents. But that's the first point, right? Operating agreement is controlling. So you need to read your operating agreement to see exactly what applies to your situation. Second point I want to make is capital calls should be the last resort, right? So if you're a manager in a deal or a GP or a sponsor, before you get to this point where you need to think about doing a capital call, you need to have exhausted all other options, all other remedies. So for our documents, that means, did you try to do some sort of member loan? Did you try to do a manager loan? Did you try to, maybe do some sort of third party loan? Maybe you need to bring in new investors into the deal, sell new interests in the company. And if you exhausted all of those options, now this is your last option, is to do a capital call, because the last thing you want to do is go back to your investors who you raised money from maybe a few years ago and say, hey, like, I didn't plan things right. We unfortunately need to raise more money from you guys. Otherwise, we might lose the property. So, if that is the case, then unfortunately, this is your only option. I mean, the other option, I guess, is to not raise any money and let the property fail, and potentially let the lender foreclose on the property. And if that happens, then everyone loses their money. Right. So this is the kind of decision making you have to go through if you're a sponsor. Have I gone through the process of maybe trying to find an alternative? And if I haven't, then this is my option. And what are my options for doing a capital call? Well, to give you some examples, actually, before I get into that, I mean, I think sponsors need to realize that, or sponsors and investors need to realize that, because this is a last resort, right? Because this is the last option that's available, there has to be some sort of mechanism in place to encourage investors to contribute under a capital call, because of the potential, if we aren't able to raise money under a capital call, what's going to happen? Well, you're going to lose the property to foreclosure, and everyone's going to lose their money. So there needs to be an enforcement mechanism in place to encourage or potentially force investors to contribute under a capital call. That's the thought process, or the idea behind having provisions, capital call provisions, that are more harsh and more punitive versus others that are more lax and more optional. But as a sponsor, you're kind of balancing, that, right? That idea of, hey, I need to encourage my investors to contribute under a capital call. Otherwise, the deal is going to fail and everyone's going to lose their money. You're balancing that with, hey, am I able to, raise money from investors if I have a capital call provision that is extremely punitive? Because especially in this market today, where it's a little bit harder to raise money, investors are definitely more aware and are paying a lot more attention to specific provisions within the operating agreement, like the capital call provision. So, if you're a sponsor, that's kind of what you have to balance when you're making the decision of what or how punitive do you want to be with your capital call provision. So to give you some examples, we'll start with the most punitive capital call provisions that I've seen. And the first one is dissociation. So the penalty for failing to contribute under a capital call would be to essentially be kicked out of the company. Dissociation means, you're kicked out of the company. That is the harshest language I've seen. I mean, we don't put that in our documents, but I've seen that in other people's operating agreements where, the manager has the right to essentially kick out an investor if they don't contribute under the capital call. Kind of the middle ground example is not fully dissociating the member out of the company, but you could call them like some sort of delinquent member for failing to contribute. And if they become a delinquent member, then maybe they lose certain rights. Maybe they lose the right to vote on certain things. Maybe they lose the right to participate in meetings. I mean, you can be as creative as you want. And that's another point that I should probably talk about, is the fact that you can be as creative as you want, right? These operating agreements, obviously you have to work within the confines of the LLC statutes that govern how companies are formed, LLCs are formed. But generally speaking, sponsors have wide flexibility on how they can draft these provisions. And it's really up to them and their attorneys on, what penalty they want to put in place. You can be as creative as you want. So, having some sort of middle ground like that, where maybe you lose some rights to participate in the company, but you don't lose all your rights. Like, you still have the right to receive cash flow. You still have the right to receive distributions. And then obviously you would be diluted too, because you would have investors that do contribute, increase their percentage in the company at your expense because you're not contributing. Which brings me to the last example, is some sort of dilution penalty. I've seen, and I put this in a few of our documents, where essentially the manager has the right to sell new interest. If you don't contribute under a capital call, the manager could sell new interests that are valued at a higher multiple than yours. So normally you'd be diluted like 1-to-1, but the manager could sell interest at 1.5x multiple, which essentially doubles or 1.5 times your dilution penalty. So your percentage interest in the company will become much, much smaller if you don't contribute under the capital call. But again, those are just examples. So you could be as creative as you want when you are, drafting this or discussing with your attorney on how to draft this provision. It's really up to the sponsor to, figure out, again, how punitive do you want to be to investors, to ensure or to kind of encourage investors to contribute under a capital call, because again, this is the last resort. If this fails, then you could potentially lose the property under foreclosure, and everyone can lose their investment. So that's the thing that you have to kind of weigh when you're discussing the drafting of this provision. That being said, if you are a sponsor right now dealing with that and going through the capital call process right now, or if you're an investor in a deal and the sponsor is going through the process of doing a capital call, the operating agreement controls. So whatever operating agreement you have in place and what the capital call provision says in that specific operating agreement, that's how it needs to be run. If you try to do some sort of alternative capital call, you need to make sure that that flows with the operating agreement. So you need to make sure that the operating agreement allows for that. Maybe that means taking some sort of vote, or maybe that means amending the operating agreement in some way. If you don't do it properly, what is the risk? Well, typically there's probably some sort of provision that governs conflicts between members and the manager. Can members pursue a lawsuit against the manager for not running a capital call correctly? It depends on what the operating agreement says. They could definitely, try to file a lawsuit against you for not properly following those procedures. So again, make sure that you read the operating agreement, make sure that you follow it exactly how it's written, because that is the governing document. But happy to answer any questions, any more questions about capital call, or anything related to that. That being said, that is all I had for the topics that I want to talk about. We did get a few questions in beforehand, which I will answer first, and then I will answer the questions that came into the chat. So give me a second. Let me pull up the questions I got through email. So first question I got was from Kevin, and he asked, I am now seeing a lot of sponsors starting a preferred equity fund versus doing a capital call. How does that affect the deal? Should that process or potential event not be spelled out in the operating agreement beforehand? How does a LP have any say in the matter regarding the preferred equity raise? So great question. So first of all, preferred equity, to explain it for the people that don't know it, but basically, it's just a different class of investor. Your normal investors that come into the deal through the raise would be common equity, and then say you needed to raise additional funds. Well, one option is to offer preferred equity in the company, which would have preferred rights over the common equity. So the preferred equity would, number one, receive distributions before the common equity investors. And in the case of dissolution, if the company were dissolved, the preferred equity would be paid out first. Typically, what I've seen, normally the deal, if a deal involves preferred equity or pref equity, it's probably set up initially as an entity with preferred equity. So there'll be like a Class A investor, and then the other investors that come into the deal will be Class B. To do so later down the road, instead of doing a capital call, well, again, that's going to all depend on the operating agreement. And you brought up, Kevin, what if that's not spelled out in the operating agreement? Well, if it's not, then, if it doesn't specifically say that the manager can sell preferred equity in the company, and he's doing that, I think that could potentially be a violation of the operating agreement. Just because it doesn't specifically gives them authority, maybe he has authority to sell additional interest, or maybe the operating agreement says that he needs to take a vote anytime he does something that's not specifically spelled out. But again, every operating agreement is different. It's going to depend on how it was drafted and whether or not there is a mechanism in place to allow for that. But if he's doing it without taking a vote and it doesn't specifically give him the authority to do that, then I would say the passive investors in that deal might have a cause of action against the manager. But again, you need to go through the process. Well, number one, you need to read the operating agreement, or maybe hire an attorney to read the operating agreement for you, to make sure that he's going through the right process of doing that before it gets to that point. But if he's doing it properly, the proper way to do it is if the operating agreement has a provision, the capital call provision says if a capital call fails, then the manager has the right to sell new interest that could be senior to the current investors. If the operating agreement says that, then he has the right to sell preferred equity in the deal. And if that's the case, then as an LP, as a passive investors, unfortunately, you don't really have any recourse, because that's what the operating agreement says. You signed the operating agreement, assumingly, and that's one of the provisions that you agree to. And unfortunately, you could try to sue the manager or to try to stop it, but whether or not you're going to succeed, it's hard to tell. But if that's what it says in the operating agreement and you signed it, then unfortunately you probably don't have much recourse. So that was the first question that we got. We got another question, or I guess more of a comment, from Elijah, talking about Gene's new video recently about fund to funds. If you haven't seen that video, go to our YouTube page. You can watch that video about fund to funds and issues with accepting money from a fund of funds. But Elijah commented, Gene scared me with that video on fund of funds charging acquisition fees. I don't think even 2% of the 150 plus fund of fund managers I know even realize what's going on. I'm trying to pivot my business into working on large JV and co-GP equity placements where there's active participation from the investor. So Elijah kind of alluded to what Gene talked about in that video was, if you're doing a fund of funds, and to give you anyone that isn't aware or not familiar with fund of funds, so if you have a syndication and you are raising money from basically another syndication, right? So a fund of funds is essentially you set up a fund to invest into other funds. You set up syndications to invest in other syndications. Well, if you're doing that, one of the issues is basically having a unregistered broker dealer, right? So someone who is selling securities on behalf of another without being properly licensed, which can come up in these situations because you have the sponsor of the fund of funds who is basically bringing their group of investors, their fund, to the underlying fund or the underlying syndication. And depending on how they're compensated, they could be seen as a unregistered broker dealer. And if that's the case, they're not only putting their fund of funds at risk, they're also putting the underlying syndication fund at risk, because the SEC can potentially impose penalties against both funds for this transaction. But again, watch Gene's video. He goes way more in depth into it was a recent court case in Texas where someone was investigated basically for being an unlicensed broker dealer because of this fund of funds that he was setting up. But to kind of give you the gist, it's all dependent on how the manager of the fund of funds is being compensated. If they receive transaction-based compensation, which the classic example is some sort of commission. So if they're receiving some sort of commission from the fund to basically bring their investors into the deal, and they're not properly licensed, then that is illegal. They can't do that, and the Securities Exchange Commission or FINRA could potentially go after him, can go after his fund, and can go after your fund for entering into that transaction. So those were the questions that we got beforehand. We got a couple questions in while I was talking. First one from Joshua. He asks, "Hi John, I am starting my first private equity fund. What legalities will I need to have in place? How much would it cost me and turnaround?" So Joshua, you might not have been here earlier when I was going over basic overview of SEC rules, but if you are raising money, which it sounds like you are doing because you're doing a private equity fund, then the SEC says that you need to either register your securities with them or find some sort of exemption. The number one exemption that people use, and the number one exemption that our clients use, it's what's known as a Regulation D Rule 506B offering. For that, you are not allowed to solicit investors, so you need to make sure that any investors you bring into the deal, you have a pre-existing relationship with them, and all the investors are either accredited or sophisticated. You're allowed up to 35 sophisticated investors. And then the last major thing you have to do is provide a disclosure document to them, which for the case for 506B offering, it's called the PPM, the Private Placement Memorandum. But basically, first thing you need to do is reach out to a law firm like us, engage a securities attorney to, number one, advise you on all these rules, and then draft all of the documents that you need, like the PPM and the operating agreement. Cost for a 506B offering, to give you a general range, I would say legal costs about $10,000 to $20,000, give or take. Depends on the complexity of the deal, how much money you're raising, a lot of issues to go over before I can give you a specific quote. If you do want a specific quote, and this isn't just for Joshua, but for anyone watching, feel free to give us a call. If you go to our website, tnllp.com, that's tnllp.com, you'll see like a orange or red button at the top that says consultations. You could schedule a free consultation, 30-minute consultation with myself or Gene. And during that call, I'd be more than happy to give you a custom quote about our legal fees and costs. So that was that question. Done. Next question from Steve. We have an LLC that has a portfolio of investment properties. We wish to grow that portfolio within the same LLC and bring in additional investment equity in increments, for example, $5 to $10 million increments, to go buy more properties one at a time. What type of PPM should be prepared? So again, it's difficult for me to answer that question with just that information. What type of PPM? There aren't really types of PPM. I think you mean what type of offering that you should do: 506B, 506C, Regulation A, Regulation CF. One of the questions to decide which type of exemption to use is, do you need to solicit investors? Because if you do, then your only options are 506C, Regulation A, or Regulation CF. The next question is, do you need to bring in investors that aren't accredited? Because if you do, then your only options are Reg A and Reg CF. Next question is, are you willing to spend $100,000 in legal fees and costs? If you are, then Reg A could be an option. Are you willing to wait 6 months to a year before launching? Regulation A could be an option. Or do you need to do something sooner? Then some of the other types of offerings are probably more applicable to yours. That being said, it looks like you're doing some sort of fund where timing isn't that big of an issue. So Regulation A could be potentially possible. Sorry, I see your comment now. We do not need to solicit and they are accredited. Okay, perfect. So if that's the case, if all of your investors are accredited and you don't need to solicit, then the answer is easy. A 506B offering is probably the best for you because it's, again, relatively cheap compared to Reg A and Reg CF, and it's incredibly fast. If all of your investors are accredited, that's perfect. 506B, one of the benefits, because you're not allowed to advertise, you don't have to go through that verification process for accredited investors. So, investors who come into your deal, all they need to do is check a box when they invest that says they're accredited. But again, happy to talk on the phone with anyone about their specific deal or specific offering. So Jeff asks, do you think the SEC will target, outlaw, or just wait for a fund-to-fund manager to mess up before they do something? Or will they provide for some type of licensing for fund managers? So good question. It's hard to tell. I can't speak for the SEC enforcement division. I don't work for them, so I don't know what their process is for finding these people that are operating unlicensed as unlicensed broker dealers. I will say what I've seen from my own experience, how these issues kind of come up is usually, number one, there's some sort of disgruntled investor. So maybe the deal lost money and the investor is pissed and they go complain to the SEC or their state securities board, basically saying, hey, this guy that raised money from me, he did so improperly. He did so without a proper license. And then, the state securities board and maybe the SEC, they'll open a file with this guy and investigate. That's one way it could happen. Another way I've seen it happen is someone who wasn't licensed and goes through one of these transactions and then later becomes licensed, and during the licensing process they're supposed to disclose a bunch of stuff, and it's correct that they need to disclose all of this, but maybe they shouldn't have disclosed it, because now you're just, you're giving the licensing board, a kind of string to pull on, a thread to look at and investigate, because of these past deals that you were in, that maybe you raised money for, and received compensation that you shouldn't have received. That's the other way I've seen it happen. But the number one way I would say is there's some sort of disgruntled investor, and they file a complaint with the SEC, or a state securities board. To answer the second part of your question, though, will they provide some type of licensing for fund managers? No, I don't think they'll provide licensing, because there are licenses already in place, like a Series 65, Series 7, Series, I don't know, all the series licenses. Those are the ones that you're supposed to get if you want to sell securities and received transaction-based compensation. That's the whole problem, right? Like, they see people that are selling securities without going through these proper licensing channels. So no, I don't think they're going to provide, a new license for these fund managers, because the licenses already exist. Looks like that was the last question that came in. Oh, okay. We got another question from Jeff. How can a manager create a method to pay themselves? Good question. Okay, so to explain it, I guess, better, because I guess I didn't do a good job of explaining it, right? If you're a fund of fund, and if you're a manager of a fund of fund, and you're receiving compensation from the underlying fund, that could be considered transaction-based compensation, because you could be essentially receiving commission for bringing your fund of funds to the fund. However, if you set it up so that your compensation only comes from your investors, so your fund to fund is the only entity that is paying you, then in my opinion, you would be okay. You wouldn't be receiving transaction-based compensation. You would be receiving compensation that would flow under the issuer exemption, right? You are allowed to sell your own securities under the issuer exemption. So if you're the manager of a fund to fund, you're allowed to sell that fund's securities. So you don't need a license to do that. The issue only comes up, and again, watch Gene's video because he goes way more in depth about this topic. The issue only comes up if the manager of the fund to fund is receiving compensation from the underlying fund that he's investing in, like some sort of kickback. Then if that's occurring, the SEC potentially could see that as being an unlicensed registered broker dealer. But again, Gene's video, you should watch that if you haven't already. Our YouTube channel, we cover a ton of these topics. Look up Trowbridge Nieh Law Group on YouTube to see all of our videos that we've done. Donna asked me to clarify that again. So, well, I'm trying to I have it in my brain, like this picture, right? Okay. So a fund of funds, there's two entities, right, that you have to worry about. There's the underlying fund. Let's just call that the syndication LLC, right? That's the one that's going out and buying deals, buying properties, or buying a single deal, right? Under a fund to fund model, there is another entity, the fund of funds LLC, that is raising money separately, that is investing in the syndication LLC as a passive investor. So normally, you just have a list of passive investors that are in the deal, and they're individuals, right? The investors are individuals. Well, what if there's an entity that is an investor in the deal, and that entity itself is raising money as a fund of funds? That's the situation that we're talking about, right? There's a fund of funds that's raising money on its own from its own investors, investing into the syndication LLC. Well, if the manager of the fund of funds is getting paid by the syndication LLC, The SEC could potentially see that as the syndication LLC paying a commission to the fund of funds manager for introducing their investors or selling securities to their investors. You can't do that without being a licensed broker dealer. And if you do that, and the SEC gets wind of it, you're putting not just yourself at risk, but your fund of funds at risk. You're putting the syndication LLC at risk. Is that clear? Does anyone else have any comments or issues about that, the fund of funds issue? Again, I feel like I keep repeating myself about Gene's video, but Gene's video, he goes way more in depth about this issue. So go to our YouTube channel and watch that video if you haven't, or watch the other videos that we put together. But it looks like that was the last question. Again, if you have more questions, feel free to contact us. Gene and I, we give free 30-minute consultations. Just got to go to our website, tnllp.com, or wait until the next time we do one of these Q&A sessions. This is the second time we've done it. Probably going to do it every other month or so. I think that probably sounds like a good time period in between to let you guys kind of stew on questions, come up with new questions, talk about current events, what's going on in the securities world. But again, thank you guys for your time. This was fun. I would say. Yeah, I will definitely do another one of these. So if you're not part of our email list, feel free to join that. Go to our YouTube page, go to our website, give us a call. Happy to answer any questions that you guys have. Again, thanks for your time, and hopefully see you guys next time.